If you have a pending green card application, if you're planning to apply for citizenship this year, or if you're a green card holder who's been living in the United States thinking everything is fine, you need to stop what you're doing right now and listen very carefully, because as of February 2026, USCIS has implemented sweeping policy changes that are affecting hundreds of thousands of immigration cases across America. And what's happening behind the scenes at immigration offices nationwide is something that almost nobody is talking about clearly. So let me break down exactly what's going on, who's being affected, what you need to do immediately, and the critical mistakes that could destroy your immigration case in the next few months. Here's what just happened. USCIS issued multiple policy memorandums in December 2025 and January 2026 that fundamentally changed how they're processing green card applications, citizenship petitions, work permits, and almost every category of immigration benefit. And on top of that, we're seeing the Trump administration's expanded travel ban affecting applicants from dozens of countries. New fee increases that went into effect January 1st, making everything more expensive. A complete overhaul of the citizenship test that's now twice as hard as it used to be. And perhaps most alarmingly, a massive increase in requests for evidence, interviews, denials, and processing holds that are leaving people in limbo for months or even years without answers. Let me start with the most urgent development that's affecting people right now in February 2026. USCIS has placed adjudication holds on all pending benefit requests filed by or for foreign nationals who are citizens of or were born in countries listed in Presidential Proclamation 10998 issued in December 2025. And this expanded travel ban now covers significantly more countries than the previous version, which means if you're from one of these high-risk countries and you filed an application for a green card, work permit, visa extension, or any other immigration benefit, your case is frozen, it's not being processed, it's sitting in a queue waiting for what USCIS calls comprehensive re-review. And nobody knows exactly how long this is going to take. But here's what makes this even worse. USCIS is also going back and re-reviewing approved benefit requests for people from these countries who were approved on or after January 20th, 2021, which means even if your green card was approved 3 years ago, even if you've been living and working in the United States legally this entire time, USCIS can now call you back for additional interviews, request more documentation, and in some cases revoke approvals that were already granted. And this is absolutely unprecedented in modern immigration enforcement. Now let me tell you who's being affected. If you're a citizen of or were born in Yemen, Somalia, Syria, Iran, Libya, North Korea, Venezuela, or any of the other countries added to the December 2025 proclamation, your case is impacted. And this applies to employment-based green cards, family-based green cards, asylum-based applications, adjustment of status petitions, H-1B visa extensions, L-1 transfers, and basically every immigration category except for a few narrow exceptions, including green card renewal applications on Form I-90, citizenship applications on Form N-400 for everyone except Yemeni and Somali nationals, athletes participating in major sporting events like the Olympics or World Cup, and cases where USCIS determines that approving the benefit serves the national interest of the United States. Here's what this means practically. If you filed your green card application last year expecting a decision in 6 months and you're from one of these countries, you could be waiting indefinitely. Your work permit might expire while you're waiting. Your priority date might become current, but you can't move forward with the final steps, and there's no clear timeline for when USCIS will finish their re-review process, because the January 1st memorandum says they'll issue operational guidance and prioritize a review list within 90 days, but that's 90 days just to figure out how they're going to review cases, not 90 days to actually finish reviewing them. Now let's talk about what's happening with requests for evidence, because this is where things get really frustrating. Immigration attorneys across the country are reporting a dramatic increase in RFEs that are poorly written, don't make sense, contradict USCIS's own policy guidance, and in many cases don't even identify what evidence is supposedly missing from the application. I'm talking about RFEs that are just copy-pasted blocks of regulatory language with no analysis, no explanation of why the evidence you already submitted isn't sufficient, and no clear guidance on what you're supposed to provide to satisfy the officer's concerns. And the reason this is happening appears to be USCIS's increased reliance on automated systems and artificial intelligence tools that are generating these notices without meaningful human review. Immigration lawyers are calling this AI hallucination, where the system produces output that looks official but is factually incorrect, internally inconsistent, or completely untethered from what you actually submitted in your application. For example, we're seeing RFEs that claim you didn't provide evidence of your education when your diploma and transcripts are right there in the packet, or RFEs that cite irrelevant legal standards that don't apply to your case category, or RFEs that request documentation that USCIS's own policy manual says is not required. Here's another troubling trend that's costing people thousands of dollars. Premium processing for discretionary petitions, like EB-1A, Extraordinary Ability, and EB-2, National Interest Waiver cases, has basically become a waste of money in 2026. Because what's happening is people are paying the $2,800 premium processing fee, expecting a decision within 15 days. But instead, they're getting an immediate, poorly written RFE. Then they submit a comprehensive response addressing all the officer's concerns with dozens of pages of additional evidence, and then they get a swift denial that completely ignores their response as if the officer never even read it. Immigration attorneys are now advising clients to avoid premium processing for these categories and file under regular processing instead because they're seeing significantly better approval rates when officers have more time to actually review the case properly instead of rushing through it in 2 weeks. And this is particularly important if you're applying for an employment-based green card through Extraordinary Ability, National Interest Waiver, or any other discretionary category where the officer has substantial latitude in making the decision. Let's talk about ability to pay RFEs because these are making a huge comeback in 2026. USCIS is dramatically increasing requests for employers to prove they can afford to pay the wages they're offering to foreign workers. And officers are requesting detailed accounting of the employer's entire roster of I-140 beneficiaries, financial documentation beyond what regulations actually require, and evidence that USCIS's own policy guidance says is unnecessary. The law is very clear. An employer can establish ability to pay through annual reports, federal tax returns, or audited financial statements. And once you prove the wage for one employee, you don't need to relitigate the company's finances for every single petition, but USCIS officers are ignoring this and sending RFEs that contradict their own rules, which suggests either inadequate training or over-reliance on automated triggers that aren't connected to actual legal requirements. Here's something else that's catching people completely off guard. USCIS is issuing what immigration lawyers call bona fide job opportunity RFEs, where they're questioning whether the job offer is real, particularly for consulting firms, technology contractors, and companies with third-party client placements. Officers are requesting job offer letters, vendor agreements, end client confirmation letters, corporate formation documents, proof of ongoing business operations, and in some cases they're basically re-adjudicating whether your employer's business model is legitimate rather than just confirming that a job exists for you. And this is creating enormous problems for IT professionals, engineers, consultants, and anyone working in staffing or contracting arrangements. Now let me tell you about an absolutely illogical trend that's rejecting valid experience letters. USCIS is denying cases because experience letters from previous employers don't explicitly state whether the employment was full-time or part-time, even when the letter documents many years of work. So for example, if your green card category requires 6 months of qualifying experience and your former employer writes a letter confirming you worked there for 10 years, USCIS is issuing RFEs saying, we cannot determine whether at least 6 months of this was full-time employment, which completely defies common sense and contradicts the preponderance of evidence standard that's supposed to govern immigration adjudications, where the question is whether it's more likely than not that you meet the requirement, not whether you provided hyper-technical precision on every minor detail. Let's shift to citizenship because if you're planning to apply for naturalization in 2026, the rules just got significantly harder. Starting October 20th, 2025, USCIS implemented the new 2025 civics test, which doubles the number of questions you have to answer during your citizenship interview. You now face up to 20 civics questions instead of 10, and you must answer at least 12 correctly instead of just 6. And the question bank has expanded from 100 questions to 128 questions, covering more complex topics, including federalism, constitutional amendments, state and local government structure, and recent civic developments. On top of this, USCIS issued a policy memorandum in August 2025, dramatically changing how they evaluate good moral character for citizenship applicants. And instead of just checking whether you have a criminal record or violated immigration laws, officers must now conduct holistic assessments of your positive contributions to American society, including your community involvement, volunteer work, family caregiving responsibilities, educational achievements, employment stability, tax compliance, and overall behavior as a prospective citizen, which means you need to bring significantly more documentation to your citizenship interview than you did in previous years. Here's what this means if you're applying for citizenship in 2026. You can't just show up with your green card, passport, and basic documents anymore. You need evidence of your positive attributes, including letters from community leaders, religious figures, employers, and neighbors vouching for your character, certificates from volunteer work or community service, proof of all tax filings and payments for the past 5 years, evidence of child support payments if applicable, documentation of educational programs you've completed, and anything else that demonstrates you're not just eligible for citizenship on paper, but that you actually embody the values and responsibilities of being an American citizen. Now let's talk about processing times because this is causing massive anxiety. In 2026, USCIS processing times remain painfully slow, with most petitions taking several months or even years to reach a decision. And the backlogs are particularly bad for family-based green cards, I-130 petitions, adjustment of status applications, naturalization applications in high-volume cities, and basically every category where demand exceeds USCIS's processing capacity. For example, I-130 family petition processing times in some service centers are exceeding 18 to 24 months. Adjustment of status interviews are being scheduled 12 to 15 months after filing in cities like Los Angeles, New York, Miami, and Houston. Naturalization applications are taking 10 to 18 months from filing to oath ceremony. And employment-based green card cases are stuck in years-long backlogs for applicants from India, China, Mexico, and the Philippines due to per-country visa caps. Here's what makes this even more frustrating. USCIS just announced on February 20th, 2026, that they're proposing a new rule to overhaul the asylum and work authorization system, which would eliminate or significantly restrict work permits for asylum seekers. And while this rule primarily affects asylum applicants, it signals the administration's broader enforcement priorities and suggests we're going to see continued restrictive policies across all immigration categories throughout 2026. Now let me tell you about automated I-140 revocations that are happening incorrectly. USCIS is issuing revocation notices in employment-based green card cases claiming that beneficiaries failed to pursue visa processing within 1 year after their priority date became current. But in many cases, USCIS is wrong. Either they claim they sent a notice to pursue consular processing when no such notice was ever received, or they're revoking cases where the priority date was never actually current due to visa bulletin retrogression, and these errors strongly suggest automated systems are generating revocations without adequate human verification or safeguards. Let's talk about fees because 2026 brought significant increases. On January 1st, USCIS implemented inflation-adjusted fee increases for asylum applications which now cost $102 annually. Initial work permits for asylum and parole applicants which increased from $550 to $560. Temporary protected status applications, which jumped from $500 to $510, and various other applications across the board. And these increases come on top of the massive fee hikes from July 2025, when the One Big Beautiful Bill increased green card adjustment of status fees, TPS fees by 900%, humanitarian parole fees by 59%, and Board of Immigration Appeals fees by 718%. Here's the critical question everyone's asking. What should you do right now if you have a pending application or you're planning to file? First, if your case is subject to the adjudication hold because you're from one of the high-risk countries, you need to monitor USCIS announcements closely for when they release operational guidance on the re-review process, which should happen by early April 2026. And in the meantime, make sure all your contact information is current with USCIS because they may request additional interviews or documentation without much notice. Second, if you're planning to file a green card application, particularly through employment-based categories like EB-1A, EB-1B, or EB-2 NIW, seriously consider filing under regular processing instead of premium processing, unless you have an urgent deadline, because regular processing is producing significantly better outcomes right now. Third, if you receive an RFE that doesn't make sense or contradicts USCIS policy, do not ignore it. You must respond within the deadline, but consider working with an experienced immigration attorney who can identify when the RFE is legally incorrect and craft a response that pushes back appropriately while still providing whatever evidence might be helpful. Fourth, if you're a green card holder planning to apply for citizenship, start gathering your evidence package now. Get tax transcripts for the past 5 years, request letters of recommendation from community members, compile proof of volunteer work and civic engagement, organize your travel records, and make sure you can demonstrate continuous residence and physical presence. Fifth, if you have a conditional green card based on marriage, do not miss your Form I-751 filing deadline, which falls within the 90-day window before your card expires, because missing this deadline terminates your status and could put you in removal proceedings. Sixth, if you're a green card holder who travels internationally, keep all trips under 6 months whenever possible, maintain detailed records of your travel dates and purposes, and carry evidence of your ties to the United States, including employment letters, property documents, family information, and tax returns in case you're questioned at the airport when you return. Seventh, check the visa bulletin every month if you have a pending green card application because priority dates are moving forward and backward unpredictably in 2026, and you need to know when your date becomes current so you can file your adjustment of status application during the window when USCIS is accepting filings. Here's what immigration attorneys are seeing on the ground in February 2026. Increased secondary inspection at airports for green card holders from certain countries, more frequent requests for additional evidence even in straightforward cases, longer interview scheduling times, more denials based on technicalities that would have been waived in previous years, and a general atmosphere of heightened scrutiny across all immigration benefits. The Trump administration has made clear that immigration enforcement is a top priority, and that's translating into stricter adjudications, more aggressive use of discretionary denial authority, expanded travel restrictions, and reduced tolerance for anything that might be considered a weakness in an application. Now, let me give you some perspective on what this means long-term. If you're living in the United States on a green card and your ultimate goal is citizenship, 2026 might be the year to seriously accelerate that timeline because citizenship provides protection that permanent residence simply doesn't offer. You can't abandon citizenship by traveling. You can't have it revoked except in extremely rare fraud cases. You get voting rights and full political participation. You can sponsor a much wider range of family members. And you're protected from deportation in almost all circumstances. The current environment suggests that being a citizen is significantly safer than being a permanent resident when enforcement priorities keep shifting. Here's my final warning. Be extremely careful about immigration advice you see on social media, YouTube, TikTok, or random websites, because there's an enormous amount of misinformation circulating right now. And I'm seeing people make terrible decisions based on rumors, outdated information, or outright scams. Always verify immigration information through official USCIS.gov announcements, consult with licensed immigration attorneys for personalized advice, and never pay money to anyone who promises guaranteed approvals or claims they have special connections inside USCIS because those are classic fraud schemes that target vulnerable immigrants. The bottom line in February 2026 is that the immigration system is more complex, more restrictive, more expensive, and more unpredictable than it's been in years. And if you have anything pending with USCIS or you're planning to file an application, you need to be more careful, more thorough, more strategic, and more proactive than ever before because small mistakes are being punished, technicalities are being used to deny cases, and officers have enormous discretion that they're using more aggressively under current policy guidance. This is not the time to cut corners, file incomplete applications, miss deadlines, or hope that USCIS will overlook problems. You need to get it right the first time, because fixing mistakes is exponentially harder and more expensive than doing it correctly from the start. This information is for educational purposes only and does not constitute legal advice. Immigration laws and policies change frequently, and every case has unique circumstances. Always verify details through official government sources at uscis.gov. Consult with a qualified, licensed immigration attorney before making decisions about your immigration status, and do not rely solely on this video or any social media content to determine your eligibility or legal options.